Yo, yo, yo. Hopefully you can see me and hear me. I just had an interaction a couple days ago with Judge Joe Brown. Judge Joe Brown. A TV judge, actual lawyer. And I just had the chance to talk to him about some law. And I wanted to share that with y'all and explain that this guy's like 77 years old. He's done law his whole life. And lots and lots and lots and lots of practice, right? Me, on the other hand, no law. I don't do law. I don't understand law. Um, at least I didn't until about a year ago. And what's been happening is I could see, like many, that we're headed quickly to a place that isn't good in our nation. That where government is just running over people, running us over, taking our stuff. COVID was nuts, and so I just I did lots of praying and seeking and reading and asking for what can I do to help preserve our nation, our states, and my children's posterity. Like, how did we get to here, and how do I be a part of um, passing a nation and state down to my kids that um, won't attack them, but will do what they're supposed to, which is to help and benefit them. So anyway, um, I found a dude named Dave Jose through a guy named Jaron Jackson in Oklahoma, who was talking about Christ and God and the Bible, and then how there's something called the common law that um, people haven't been taught about. And so as I learned more and more, and Jaron kept talking about this dude Dave, and so I found Dave and started studying with him. And it's maybe been 8 months or something like that, 9 months, 10 months. I've done some webinars with Dave, and read a lot of stuff he pointed us towards. And holy moly, yo! So this is like 8 months of me studying, and just pay attention. Like, I'm talking to a guy who's been a judge, celebrity, and like 50 years of law experience. And I'm 8 months of studying some basic stuff. And I just wanted to share this interaction and see, memorialize it, but also put it out there so people can see it and hear it. So I may stop a few times to point something out, but let's roll.
Really? No. It's going to be real quick.
No. I need to go.
There are no emotions. It's just fact.
I need to go to Raleigh.
Cold-blooded, rational fact.
Cold-blooded fact.
Okay.
Just hold it. Raleigh, you have the floor.
God bless y'all. I appreciate the mic, and I appreciate the judge and y'all being here. I wanted to, if I could, I don't often get to speak to a wise old man judge like I do tonight. So I wanted to if I could, maybe zoom out a little bit, and I hope it doesn't go off track a little bit. But I think it speaks to what we just heard a little bit too. I've recently been diving into some learning some fundamental principles of law, and because I read in a lot of state constitutions where it talks about, like for instance, Virginia Section 15, Bill of Rights talks about a frequent recurrence to fundamental principles is how we keep a free government. And I didn't know what those were. And since I've been studying and found basically they're talking about maxims of law, which I think the judge is pointing to when he's talking about it doesn't require proof, because that's what maxims are. They are chief conclusions of reason. And so, with respect to the maxims, Judge, I wondered if you had been taught those, if you've heard of those, and if you know that they're connected to due process of law.
Yes. I have one of the most frequent ones that we got taught long time ago that a lot of today's lawyers have never heard of. This old maxim: it is better for 100 guilty men to go free than one innocent man to be convicted. Now, that's a maxim. Maxims are ideals within the law and maxims. And then you have the principles of law, which are general. The principles of law generally constitute what's known as the common law. And then there are modifications to the common law, if not outright disregards of it, that come from statutory.
Can I ask you about that? So,
ahead.
like, one of the maxims that I've found, and what I've kind of referencing is Charles A. Weissman's collections of maxims. That's kind of what I've sent. Now, you'll notice he ignored completely my linking the maxims to due process of law. And the reason why I said that is because they are connected. They're required to be observed whenever you are given due process of law, which the government is sworn to give in the text of every state constitution and the federal. So you notice he ignored that. Centered on because it kind of categorizes them and puts them in, and I got a searchable format too for them. So, but one of them is that anything derogatory to the common law cannot be drawn into precedents.
Yeah, that's an old maxim. Yeah, that's right.
And then so like statutes and case law, if you will, can't be used because the common law definition, or Black's Law 4th or 3rd or earlier, tells you that the common law is distinct from statutory law or enactments from legislatures.
Right.
So, like, if you can amend the common law with statutes, it would appear that would violate that maxim.
Well, here's what the first.
So he got stuck right there with the maxim. I ain't smart. I didn't know that. I didn't know anything about the common law 6-8 months ago. And now I've learned the maxims and what common law is. And the judge is stuck. He agreed with the maxim because you have to. Because they're not negotiable. They're chief conclusions of reason. So he's stuck. And then you'll see what he does here.
First case the U.S. Supreme Court heard way back in the 1790s. It dealt with the.
He moves to a case. We're talking about fundamentals and how in the common law, and it can't be abrogated by statutes or cases, case law. And he moves directly to a case when he got boxed in.
The Sixth Amendment, that says no case tried before a jury upon the common law shall be heard upon appeal except upon application of the common law. What is the common law? The U.S. Supreme Court cited a 1661 case heard before the English House of Lords.
Notice he didn't cite this case. Anybody notice that? Something to keep note. And then he's going to have another case that he brings up. Doesn't cite it. But it sounds like he's going to read from one of them, which is interesting.
And they said, quote, all law in the United States is the common law until it is superseded by regulation or ordinance. The common law is, quote, that body of judge-made law based on tradition, precedent, and the evolving conditions of society, unquote.
Yes. Yeah. So what
in other words, it's common law unless the state legislature overrules it. Now, there is a case called Marbury versus Madison, 1803.
Who knows that one?
That says even if a legislative body, in this case the U.S. Congress, passes a law, it still has to match the Constitution. And if it does not, then it's invalid.
It's void. So here's what he just said. So he cited Marbury, actually, right? and it says Marbury says that if a statute violates the Constitution, it's void. So if you have a statute that violates the constitutions, all of them are void, then how can a statute abrogate the common law? Because the constitutions in America are the common law in America. So he just destroyed his own argument in case law land. But that's where they want to keep you. They want to keep you arguing cases because there's cases that say this, cases that say that, cases that say all this stuff, or you can't say nothing unless you got a case. And that's all a big freaking hoax because case law is judge-made law, which is a freaking hoax per the maxims, per common sense, per God, per you cannot make law as a judge. You can only say what the law is, and I show him in the maxims, and he agrees with them because he has to, and I think partially because I was pretty gentle, and so he's like, yeah, yeah. So if you just read a maxim and you're just like not attacking, most people are going to agree, I think, but especially a judge.
So that, by the way, is one of the considerations that applies to a lot of the cases involving such things as, did Trump violate any law by having in his possession classified documents that were classified at one time? So
yeah,
that goes to that.
That's tough. But like and I'll just, I won't go too much deeper into the maxims, but one of the maxims says that a new adjudication does not make a new law, but declares the old, because adjudication is the utterance of the law. And
that's correct.
So it seems to me that the common law is not made by statutes, but made by it comes from immemorial antiquity and judges,
the Bible,
that confirm that law. Not that they make it, because in America we said the legislature makes law, not judges, the judicial.
Well,
the judicial branch is only to tell what we said.
Well, that's not
in the constitutions.
That's not
that's a max.
That's not what American law says. That's a common misconception that's been told very loud and very long. Remember, the first U.S. Supreme Court, the 9 members thereof, had all been present when the Declaration of Independence was signed. They were present during the Revolutionary War. They were present and, for the most part, participated in the passage and ratification of the Constitution in 1789, and a lot of them supported the Bill of Rights, which was ratified in 1791. They declared that, quote, all law in the United States is common law until superseded by statutory law, authority, or ordinance.
Give a freak what your
the
case
common
says.
law is, quote, that body
What's he reading
of
from?
judge-made law based on tradition, precedent, and the evolving conditions of society. That was a quote of a 1661 English House of Lords case that was heard 130 some years before.
So that's a House of Lords case in England. That's English common law. English common law statutes were used differently. In America, we froze the common law, wrote them in constitutions, and you don't get to abrogate it. With the servants don't have any authority to change anything about our rights in America, because it says it in every constitution, every state constitution, and we are above government as the people. Obviously, we created it, right? You can't create something and then be subjected to it. If you have authority to create it, you're above the thing you created. God, the people, government in America.
So that is the statement, and it also says evolving conditions of. There is a body of opinion going around now that's erroneous, that the law is supposed to have remained stagnant as it was in 1791. It does not, because the very first Curry case heard a year and so later. says that it
Well, like,
and the precedent from 130 years prior to that, 1661, in the English House of Lords, it was cited unanimously by the Supreme Court, said it evolved. So that was English common law. And that,
yeah, which I think in our state constitutions and in America, we froze it, right? So, like, I realized that
well, no,
they
we
did
didn't
use.
freeze it. For example, what is beyond a reasonable doubt? Okay, what does that mean?
He just
A jury is charged with, ladies and gentlemen, you must find that the defendant committed each and every element of the crime that is
obfuscation.
necessary to constitute the commission thereof, and you must find that he committed each and every element of this crime beyond a reasonable doubt. Now, what does that mean? Well, okay, obviously some explanation needs to be given. So that's where the common law comes in. There's common law that's been adopted by a state Supreme Court that
No.
results in what
What
are
depth?
known
We
as
need to
jury
explain beyond a
instructions.
reasonable doubt.
Although
Hey, did
you
this
never
guy do
see
it,
this in the
or do you think there's a
movies
chance he
or
did?
the television
What the
shows.
freak?
A
You're gonna need
large
some
part of the
judge to
trial
tell you
is the
what the freak
jury
words mean.
getting the instructions that the judge has written out at great length and read in the entirety to the jury. Sometimes you would
Sure.
have to read the charges for a murder case. It would take 8 hours to read them. And you've got
But
250 pages of writing that's in the trial jacket that the jury refers to. Now, what the common law is contained in these instructions. Now,
well, hopefully.
several things like what is beyond a reasonable doubt. I didn't like the charge in the pattern jury instructions. So in 1992, Judge Joe Brown of Memphis, Tennessee, wrote out an alternative charge of reasonable doubt. Some of the convicted defendants appealed that, but the Supreme Court said, although Judge Brown did not, in fact, read the pattern jury instruction as to reasonable doubt, we think that his version is better. Henceforth, this shall become the standard pattern instruction for the state of Tennessee. No legislative body moved on it, none considered it, none overruled it. For the next 25, 30 years, 35 years, that became 30 years, that became the instruction for the state of Tennessee, the law on what reasonable doubt was. And I wrote it.
Well, the challenging part, and I can appreciate that. Certainly, throughout our history, we have wise men that have wise ideas, and fix wrongs, right? Because we're always going to have some wrongs. We're always trying to strive upward, right? But like, what is subject to a judge is not subject to innovation. That's another maxim.
Well,
And then,
it is. Supposing you have a
well,
situation like the James Earl Ray case, the alleged killer Martin Luther King, where something comes up, brand new technology that can establish the pristine innocence of the defendant, in this case, James Earl Ray, that did not exist at the time the statutory rules came into effect. So, what happens when you have a totally new situation that was unanticipated by a development in humanity's state of knowledge or
well,
technology?
well, I think the judge isn't innovating at that point. The judge is just um, allowing the jury, which by the common law, you have to have, you can't take life, liberty, or property without due process of law and a court of record, moving by the common law, and a trial by jury. And you said trial by jury earlier, and you were dead on right. And I like that because a lot of people don't know. Trial by jury is different than a jury trial, where the trial by jury, the jury judges the facts and the law,
Well,
and they can nullify.
that's every jury trial. That's essentially what the law is in the entirety of the 50 states in the United
Essentially.
States. Now, what I'm saying is, by the way, James Earl Ray's thing was not a trial. It was a post-conviction relief proceeding. It was technical, but the point is at the time it got in front of me, there was no law relative to that. Now, I got reversed by the Court of Appeals, but affirmed by the Supreme Court of the state. And 2 days later, the state legislature passed an act making that the law as well, and the governor signed it.
Well, that's
So-
good because that's who should be making the law.
Yeah,
that's
but-
who the people told.
But the
to make
point is
Yeah,
this:
but-
what happens when the circumstances of humanity and society evolve to the point where the law no longer covers the specific instance? Somebody's got to be charged with accommodating those.
Well, clearly, that's what the legislature's for. They write the law. What is he even talking about? Clearly, if things change, then we need to have laws. They think they need to have laws for every dang thing. He's trying to hold on to the position that judges love, and I can see why. They think they get to judge what we wrote, as in what does it mean, instead of using the contemporaneous text. They want to say that they have authority to say something is or isn't constitutional, and be the final say. Well, the problem with that is that, like Jaron explained very well, that would elevate them above the Constitution and above the people. And that is not tenable. That is not how the system of representative government, or I would call it a republic, a constitutional republic that was formed, operates per the text. So he's going to have some problems. But
those new developments with the law, because the law is not stagnant; it is alive. For example,
Well, I think isn't that where the jury is?
No, it comes into this. For example, I say often, and this deals with gay folk, get your freak on in the bedroom.
See,
That's your business. 1979, 1980, I had a series of trials that got the jury laughing when they found out what it was about. What happened was kind of funny. This guy had a house he got before he got married, stayed married 2 years, filed for divorce. His wife was supposed to give the keys back. Girlfriend snuck by his house on lunch, parked her car around the other side of the block. The wife had a key she did not surrender. She walked in
Can we
to
get back to
some
the
papers
Maxims?
and found
Judge?
the defendant and his girlfriend going out on each other doing a 69 number. She rushed out the door, flagged down a passing cop. He comes in. We couldn't suppress his intrusion because he had an earnest belief that the woman had a legitimate authority to admit him. So he sees the guy going down, giving head to his girlfriend, and her giving head to him. So they both.
Hold on. So he's talking about regulating private affairs in somebody's bedroom, right? So he's got a problem there because he couldn't find any granted authority for any statute to attack private rights or enter into someone's private affairs. And so, yeah, it's just. Sorry, I got tied up. Here we go.
Wind up in front of a jury with a charge that carried 3 to 15 years in the state penitentiary at that time for the heterosexual act of unnatural sex acts. So one of the jurors said, "Jesus Christ, Mr. Brown, is that right?" The judge said, "Mr. Brown is informing you of the law that the court will charge you with." Jesus Christ, me and my wife do that all the time. You mean we could get 3 to 15 years in the penitentiary? And the judge said, "You shouldn't tell on yourself. You have a Fifth Amendment right, but we'll overlook that."
How
Yes,
cute is that? You have a Fifth Amendment right. but
So
you
we
can do
tried several cases
stuff
that I had
private.
several defendants on, with that being the issue. Well, not several defendants, just set of couples, because there was a mistrial the first go around. Somebody said it was just against God's law for anybody to go down on anybody. So they hung the jury up for guilty. So we tried this thing again. And this time everybody walked. But you see, these kind of things do happen. So the law
Yeah.
changes. In 1979,
I
we
want
had
I
a
want to
set
give
of
Raleigh
colored
the last
laws in
word
place.
too.
But
Yeah.
Even the
you
host
know, the
lady's
law
like, Judge,
changes, so
hush
you
up.
have
Judge,
to have it evolve to match the
well,
changing
I
conditions
I think that,
of society.
of course, I think it evolves, and I think it of course has to change at some points. But I think where kind of we get lost, I think, as just regular people who are living out here in the world, not doing courtroom stuff every day, is that we have text that created the government. And when we're told we need to, what we read, like the legislature makes the law, and case law is not um, law. It's a case, and each individual case is to be adjudicated using the applicable maxims for each to protect individual rights. And these are things I just read in you know um, my free time after work, where I'm trying to figure out what has occurred in our justice system to the point where um, we become subject to our own creation, because that's clearly wrong. Like when I read the Declaration of Independence, it says that just power is derived from the consent of the governed. And I've been taught and told
Bill in somebody's state legislature to it was unanticipated by a development instance. Somebody's got to be charged with accommodating those new developments with the law 3 to 15 years in the state.
Word too.
But
yeah,
you know, the law changes, so you have
Judge.
to have it evolve to match the
Well,
changing
I
conditions
I
of
think that,
society.
of course, I think it evolves, and I think of course, has to change at some points. But I think
I'm gonna stop messing.
where kind of we get lost, I think, as just regular people who are living out here in the world, not doing courtroom stuff every day, is that we have text that created the government. And when we're told we need to, what we read, like the legislature makes the law, and case law is not law. It's a case, and each individual case is to be adjudicated using the applicable maxims for each to protect individual rights. And these are things I just read in you know um, my free time after work, where I'm trying to figure out.
This is stuff that I've read in my free time, shown to me by Dave Jose, and this dude, he's a threshing tool created by God. He's anointed with um, specific wisdom in the law that is unmatched from what I've seen. And you can tell, like, I've taken 8, 10, 12 webinars from Dave and studied some in my free time after 50, 60 hours a week of work and 3 young girls and a wife. I've been able to gain wisdom and understanding of the fundamentals, which has put me in a place where I should not be in a sane world where God isn't doing new things. It should not put me on a plane where I can have this conversation with this judge and put him in a position where he is shown to be wrong and twist himself up, tripping over maxims, agreeing with them, but then not agreeing with them in what he says. It's crazy that this is even happening. It's all God is what I'm trying to get at.
What has occurred in our justice system to the point where we become subject to our own creation, because that's clearly wrong. Like when I read the Declaration of Independence, it says that just power is derived from the consent of the governed. And I've been taught and told that the people are the governed. And that ain't true. The truth is that the government is governed by the people because they swear oath to be governed when they sit in our seats that we created. And then when I hear that judges are making law, I can tell based on the text that we wrote, which is the highest law, that that ain't legit. We have representatives and we have expressed granted powers to them, and there is separation of powers for a reason. And so I think we've gotten some fundamental things off track for the last 50, 80, 100 years since Langdell and Harvard Law School decided we're going to roll with the case law method and trash the common law and call it the same as statute.
Well, the common
And I
law
think
is case law. Don't mean to interrupt you. In other words, there are thousands of pages of cases that lawyers and judges are supposed to either know, to understand, or to have access to looking up and refreshing what they have learned about the principles of law.
yeah, so they're vapors of the principles. So using a case can show evidence of the law. It is not the law.
Well, it is the law. In other words, see, what you deal with is this. You go in and you talk to the doctor. The doctor has been an intern and a resident in a hospital and seen hundreds of cases. He is looking
He's running away
over
from
a master
Jackson.
surgeon's shoulder and watching
talking
the
about nothing.
peculiar nature of the incision that this surgeon is making in a body organ in order to excise something that should not be there.
You got to be
You can't
smart.
describe that
You can't
in a
just
book.
read
You
it.
have to see
You can't
it.
just read and
So
understand
when
the
he's
text.
operating on you or he is diagnosing you, he has all of this visual in his mind. He has all of this experience in his mind. It's stuff that only comes to exposure, knowledge,
Only lawyers
and
have it.
wisdom in the
Only lawyers can
application
read.
and the execution of certain things. You cannot teach it. There is no way anybody is going to reduce tens of thousands of pages of case law to anybody's statutory law, but
Heck's
you
he
have
talking
to
about?
assume that there is a
We got to assume.
repository of people who, to the satisfaction of the charged state entities,
Heck's
has
he talking
passed the bar exam and been certified as reasonably competent in the practice of law to be charged with the knowledge or at least how to look these things up. Now,
yeah,
instantly, I see one thing. We see the picture of somebody in some of these things on the case we've been discussing with Sonia Massey. And this is becoming the national authority on such things, but I have on good information that the person has never tried a case. So you've got effectively a rookie and amateur who's now recognized as the master.
You talk about Ben Crump.
That's his problem. I'm the
Yeah,
rookie,
but that is
I
the
am
thing.
recognized.
I don't know. Maybe
Hurt
he's
the
have
cat.
tried a case, but I
He's
don't
sworn.
know of one.
No,
But
but he won't.
anyway,
He's representing a family for the civil suit because isn't the prosecutors they are going to be
I'm
representing?
not talking about that. I'm talking about civil suits particularly,
Okay.
because a civil suit, if you've got a badass trial lawyer, you're going to put more on the table because you know he can do more damage to you if you go to trial. If you've got somebody you know has never been to a trial or is very inexperienced, you say, I'll take it or leave it. Let's go to trial.
Mm-hmm.
And they go, well, we'll take it. Okay, fine. Then shut up and go get your client to sign off on it.
I see what you're saying.
If you have, take this.
No, I said I see what you're saying.
Well, I'll give you a
He's like,
pragmatic
Judge, shut up.
example.
Move on.
There is a gentleman still alive, still in a limited practice. He's down in Boca Raton, Florida. His name is Willie Gary. Willie Gary, out of the top 10 highest awards by juries in the history of the United States, has 4 of those cases, including the largest award to withstand appeal in the history of the United States, and 5 or 6 of the 10 largest settlements.
I think he might have said he slept
40 years ago. He got a sustained verdict on appeal for $980 million, which would be worth about $4 or $5 billion today, against a defendant. Now, do you think that man is more able to do something than somebody that gets, say, 28 million for George Floyd when the Minneapolis, St. Paul, Minnesota municipality had a $250 million liability policy? You see what I'm talking about? Yeah, I'm not casting any aspersions. I don't know all of the circumstances,
Well,
but
I want Raleigh to finish
you
up
see
because I
what
need
I'm
to
saying?
move on to the other speakers.
You
Anything
Okay.
else you want
Now,
to say, Raleigh?
No, Judge. I would I appreciate y'all's time and having me.
well,
I
you're
would
asking
encourage.
legitimate questions. These are questions that citizens should pose.
Dang right, Judge.
Well, I think what we've got to look at is like if I read any of the state constitutions, I got the Colorado one here. These are the fundamental instruments of the state, right? And the states created the federal. The federal is supreme in the 19 enumerated powers, but the states are sovereign, and the people are the ultimate sovereign and created the states. And if we're governed, so like if all the laws have to be in pursuance per the United States Constitution to the United States Constitution, and nothing in the Constitution say the people must or the people shall, then how is any statutes going against the people's rights?
Well, I can answer
How due
that.
Can you
process law?
quickly answer it? Because I gotta move on
I'll
to the other
quickly answer
speakers.
that. Here's what the deal is. The people are sovereign, but once they set up a representative government to reflect their sovereignty, they just can't opt out of it.
No,
Now,
we can alter, reform, or abolish per the
no,
text.
here's the thing.
Yes, we can.
No, you can't. Not that
Go
way.
read it.
No, listen. You
Go
cannot
read any state constitution.
listen. You cannot abolish it individually. It's going to apply to you whether you like it or not, unless
How does it apply to me? Don't tell me I have
it
to do
applies.
Now, who made the claim? If you notice, who made the claim that I can abolish the government individually? Who said that? Ain't nobody said that. So he's creating false arguments so he can rebut something, because he can't rebut the text. Everybody can freaking read it. So he has to try to confuse things and read stuff into the text. The point is, these judges and lawyers, they have to move from the text. They can't stay with the text, because otherwise they'd be looking for a job or maybe go to jail for what they've done outside of the text. That's what's coming, and it's very plain to see if you read the text and just stick to what it says. But he dances around, boy. He dances.
To you, listen to me.
How?
Listen to me. I'm telling you, because it's called power and authority. The state.
Yeah, we got the most.
No,
we have all
no. Listen.
Per the text.
State.
Read the text.
I have all of it. Now, here's
No,
the,
you
I have.
You
All right,
forgot
so
it.
No,
Man.
I didn't forget it.
Just
Just
let him
listen.
answer.
I'm trying.
All power is
Are
vested
you gonna
in the
let
people.
me
Like, I don't want
explain
this to
it
be
to you?
another back and forth.
Are you gonna let me explain it to you, or do you
Judge,
want to go?
you're trying to
We're
move
not
from the
playing
text.
ping pong.
You're trying to make law.
Look.
right now.
Let me break it down to you this way.
Right now.
He's a communist, but he said it. Mao Zedong. He said power grows out of the barrel of a gun. Now,
That ain't true. It
hold
grows out of a
on.
pen.
Oh no! Now let's check this out. So this dude got boxed in by the Maxims. I didn't write them. I ain't smart. Dave Jose showed them to me, and I've been studying the fundamental instruments in the Maxims, so I can put this dude in a box. He got so uncomfortable that he quotes Mao. That's his answer. He thinks that guns is how you fix stuff, not the law. That's it's crazy.
Hold on. The state, the collective of millions, hundreds of people, has the authority of a lot more guns than any one individual has. Now, if that individual starts a movement and that movement expands and the movement says we're not going to have it that way, they can either have a vote, or because the Second Amendment exists for this
Well, you could
purpose
just
as
tell
an
them
ultimate
Nah,
check
we
and
don't-
the
balance.
contract.
The Second Amendment if you do not
It's
have a
not true.
disarmed
Government
public,
already
allows
agreed.
the
I,
public
I,
to stay
okay,
in
real quick,
effectively another revolution.
real quick, Raleigh,
That's our way.
what is your disagreement or your grievance? Because just get to the point, because I have to get to the
Well,
next speaker.
yeah, no, it's all good. I appreciate the time. So the problem is the judge is going to have here is like I can read the text, and the text says that the people have all political power
It
of
says
every
plural,
state
doesn't it?
constitution.
It says people,
All
doesn't it?
political power.
Yeah,
All
the
political. Yeah,
people.
of course.
Of
Yeah,
course.
and who?
That
Yeah.
the
So
common law is a
Who said it
collective.
wasn't?
It does not say each
it all.
individual. Does it say each individual person?
Do we have individual
Does it
rights?
say each
Do we
individual?
have individual
Listen to
rights?
me. It says not each individual person is a sovereign. It says the people are sovereign. That's a collective. You have individual rights to keep the sovereign collective.
Now hold on. The dude said we are sovereign as a collective. So me being one of those people that are sovereign, right, in the collective, as compared to government, which we created as only servants to benefit us. Who is above who? Well, we created the servants, right? And we have them bound by right. So any one of the popular sovereignty, the collective, has individual authority over government to instruct them lawfully, to talk to them, give them a frequent recurrence to the fundamental principles, teach them, and hold them accountable in a legal way to the trust indentures, the contracts. That is what the purpose of the contracts are, to hold servants who swear to obey and be governed by us and our documents that we write. Is to hold them accountable. And they want to invert that. They have inverted that. And they got us thinking that we can vote or do violence. Those are our two options. That's a freaking hoax, per the text that they all agreed to.
Collective from imposing upon you unduly. But
All
if
right.
you
Well,
want to
Hey,
see
can I
how
make
it
a
works,
humble suggestion real quick?
yeah,
Well,
go ahead.
This guy,
Riley, I think you should just go find a compound in the woods, go arm yourself to the teeth, call the sheriff up,
Nah,
call the
homie.
sheriff up and tell him
Nah,
that you're a sovereign citizen and that you follow your own rules. And we'll just read
nah,
about you on
that's
the
a
news the
hoax,
next day,
bro.
all right?
Hey,
all right.
go.
What?
that dude that jumped in, he's a lawyer. I listened a little later. Of course he's a lawyer jumping in to save his buddy, who's getting thrashed by a regular nobody. Just learn from Dave, crushing him. So now I'm a sovereign citizen. And if you notice, Neil Gorsuch came out and told that the people are sovereign. Obviously, the people are sovereign. We created government. So is Gorsuch a sovereign citizen? Well, freak no. He's been taught and knows that we know now, thanks to Dave. And they're telling. He's telling. The government knows that the people know. And you're not going to be able to keep this under wraps too much longer. There's not less people every day that know the fundamental principles. There are more, by God. And Dave and Jaron and Chris and the whole crew, y'all know, are telling everybody. And he's going to wrap it up here with saying he would throw me in jail if I said these things to him in his courtroom, which is mine. It's my courtroom.
This is the guy being allowed to cut in.
All right.
Well,
But
if I can put the period
moving
on
on.
it,
I'm moving
you know,
on
I
to
put the
I don't
period
want
on it.
anybody to cut in unless you want to rebuttal. And honestly, I don't want to have these 10-minute back and forth.
Last quick word.
It was 30 minutes.
Here's how I dealt with it. It's not that I did not have people who advanced that. This is
He
how I
dealt
dealt
with
with it.
He did this.
Officer Williams, that's one of my bailiffs. Officer Duckett or Lieutenant Bolden, See if your keys work in lockup. If they do, please escort this gentleman back to the rear and detain him until further notice and show him what collective power of the state means.
Honestly, Judge, a lot of times
Now,
you could,
that's it.
yeah, but
That's it.
try to keep it shorter because and
That's
push. No.
So the funny thing is, I'm gonna end it here. The judge has been locked up and shown the corrective power of the state before. In 2015, he was thrown in jail for a few days for contempt because he was arguing with a judge that, I don't know, if it seemed like it was probably not a judicial magistrate, but an administrative one. But hey, he's doing what was done to him, I guess, and what made him a bunch of money and got him on TV. You know, yeah. But it shouldn't be happening. That, dude, I'm just a regular nobody who's like studied with a dude who's been shown the wisdom and truth of the law, and where it comes from, and how God's word is the bedrock of it, and where it all comes from. And more people every day are learning. So anyway, that's my interaction with Judge Joe Brown. Never thought I would ever talk to a guy named Judge Joe Brown, but I did, and unfortunately he was shown to have been wrong per the text over and over, and even agreed, and then kept wiggling around. So anyway, God bless you. Wanted to memorialize this and have a way for people to share on YouTube, because I know sharing stuff on Twitter, sometimes people who aren't on Twitter don't know how to view it or see it, or there's problems. So anyway, there you go. That's what I got. God bless you. Go get a webinar from Dave. Holy moly. God bless you. Peace.